Good morning, everyone. Welcome to our webinar on compulsory acquisition this morning. My name is Elaine Keating. I'm a Senior Associate on the Planning and Environment team in Mason, Hayes and Curran. Firstly, I'd like to welcome our speakers today. Firstly, Jarlath Fitzsimons, Senior Counsel, eminent Senior Counsel specialising in planning, environment and local government law. Welcome, Jarlath. Thank you very much. Also, Tom Kirby, Principal and Director in Avison Young, who has extensive expertise in compulsory acquisition as valuer in this area. So we have a lot to cover today. Should you have any questions, can you please pop them in the Q&A box at the bottom of the screen, and we should hopefully have time at the end of the presentation to get to those. This webinar qualifies for 1 hour CPD. So there's a short survey at the end. So if you could please complete that survey, you'll be able to download then the CPD certificate into your inbox. So thanks very much. Next slide, please, Rebecca. So just an overview of our webinar for today. So after a short introduction from myself, Jarlath Fitzsimons is going to be looking at the legal principles and statutory process. Tom then is going to take us through some valuation and compensation principles, and we're just going to be having a short panel discussion then on navigating the arbitration process, I suppose, as such, and with time hopefully at the end then for questions. So next slide. So just to give a sense, I suppose, of the breadth and the wide scope and complexity of compulsory acquisition law in Ireland, the Law Reform Commission in their 2023 report identified over 50 different legislative schemes containing compulsory acquisition or similar powers. So for today, I suppose we're focusing on some specific aspects of that, but I suppose it's just to get that sense of the complexity of this area of law. So next slide. So just in that sense, we're just going to set out this high level process, CPO process life cycle, looking at, I suppose, those different stages from identification, confirmation, through to acquisition and ultimately compensation of for the acquired land or land rights. For the purposes of today, I suppose we're looking at that kind of key Housing Act procedure, which has been incorporated into the Planning and Development Acts, and I suppose is the most commonly used procedure and process in the state. So firstly, I suppose an acquiring authority must identify that plot of land kind of for it to be compulsory acquired, and that's, I suppose, in accordance with the relevant legislation and principles that Jarlath is going to set out further. The CPO itself must be in a prescribed form and accompanied by a map delineating that area to be acquired, and there is kind of publication and notice requirements, so must be published in one newspaper, notice served on the landowner impacted. So the landowner is then afforded the opportunity to object to the CPO, and where an objection is made, the CPO is then submitted to the Commission, formerly the Board, for decision, where no CPO, I suppose a local authority, can grant. The Commission then has discretion whether to hold an oral hearing. It can seek submissions prior to confirmation. And when a CPO is confirmed by the competent authority, be it the Commission or the local authority, there is notification requirements then. So it must be published, and notice must be given to the landowners. So that decision then is subject to judicial review, and that is an 8-week period from the publication of the decision. The CPO becomes operative 3 weeks after the notice has been published, and the notice to treat must be served on the landowners within 18 months of the CPO becoming operative. There is a possibility to extend that for a further 18 months if that confirmation decision is subject to judicial review. The acquiring authority then can enter onto the lands once the notice to treat is served. I suppose to flag that the notice to treat is that date is the date at which compensation is assessed. And I suppose the acquiring authority can enter then any time, subject to serving a notice of entry with 14 days notice in advance of entry, and that's also subject to the payment of interest, which Jarlath is going to touch on shortly. There is power then, I suppose, for vesting kind of 6 months from that date of entry, and where an acquiring authority has taken possession. So the landowner is entitled to compensation to be assessed in default of agreement. And I suppose it's that second half of the CPO process that we're going to be ultimately focusing on a lot today in our presentation. But the key point to note here in terms of the position in Ireland at the moment is that compensation doesn't have to be paid or agreed in advance of possession or acquisition. So next slide, please, Becca. So just prior to our presentation, just wanted to touch on a few kind of legal developments of late. So in terms of legislation, the Part 14 of the 2024 Act is introducing new provisions around compulsory acquisition in the state, effectively consolidating a lot of the legislation that's there at the moment. That part has yet to be enacted. It's included in Block D of the implementation programme of the government, so there is no date as yet as to when that will be enacted. So for the purposes of today and at present, it's the provisions of the 2000 Planning and Development 2000 Act that are still enacted. And just to flag, I suppose the Law Reform Commission has done a number of reports, including a 2023 report, which included a draft bill that did get put as a private member's bill earlier this year, but at present it isn't in the government programme. But what is in the government programme, I suppose, is the CPO activation programme, which has identified 11,000 properties, and it's looking to really address dereliction and vacancy across the state. Just some key figures: 120 compulsory purchases were completed in 2023 when this programme was enacted, and a further 136 were completed in 2024. So just also to note, there has been a shift. Although the board and commission have discretion away from oral hearings, the policy had been that where an objection was put in place, generally an oral hearing would have been heard for a CPO, but there has been quite a shift away from that in recent times. So just to flag that, and also just to flag that there has been developments in terms of cost protection for CPO. There was a case last year in January 2024, Judge Simons concluded that the CPO decision formed part of a multi-stage development consent process subject to EIA, and therefore qualified it for special cost protection rules. And a preemptive cost order was granted in that case, King versus Bord Clonala. This is very much live before the courts, and I know Jarlath is going to touch on this. So I'm going to hand over to Jarlath now. So next slide, in terms of those legal principles and the statutory process. Thanks very much, Jarlath.
Thank you, Elaine. Good morning, ladies and gentlemen. The first point perhaps to make about the law in relation to compulsory acquisition and compensation in Ireland is that it's both archaic and arcane. It's archaic insofar as certain of the statutory provisions date back to 1845, and it's arcane insofar as it is very difficult for lawyers in general practice, never mind members of the public, to understand the nature and complexity of the statutory rules and legal principles that attend both compulsory acquisition and compensation. So it is somewhat of a specialist or niche area, and perhaps that's suboptimal from a constitutional perspective when one considers that powers of compulsory acquisition are exercised so as to effectively eliminate private property rights or to restrict the exercise of private property rights in relation to lands. So it is not, in my view, entirely acceptable that we have such a difficult area of law governing such an important imposition of restrictions on constitutional rights. As Elaine has mentioned, the Oireachtas has enacted provisions in the 2024 Planning and Development Act in relation to compulsory purchase. However, as Elaine has again identified, those particular provisions have not been commenced. And accordingly, my observations this morning are focused exclusively on the existing applicable operable provisions of the Planning and Development Act 2000 as amended. Next slide, please. But before we get to those particular provisions, one has to have regard to the overarching constitutional architecture. And the first point to make is that there is provision in the Constitution for restrictions on private property rights where such restrictions are for the exigencies of the common good. And that provision has been there since the Constitution was enacted and promulgated in 1937. So the first point to note is that powers to compulsorily acquire interests in lands are not of themselves unconstitutional. However, they may, in their exercise, be unconstitutional if certain safeguards are not met and adhered to. So, understandably, the powers to exercise compulsory acquisition powers must be exercised in accordance with the provisions of the Constitution, including in particular respecting the property rights of the affected landowner. And in order to do so, the cardinal rule is that the acquisition must be for the exigencies of the public good. And accordingly, compulsory acquisitions must be proportionate. And those are fairly well established principles of constitutional law, and their application to individual acquisitions has been considered by the courts on a number of occasions, from East Donegal onwards, more recently in around 2000 to the Clinton case. So these are well trammeled areas of constitutional law, and I think it's fair to say that the general principles are well settled. Next slide, please. So what are the principles then of compulsory acquisition, both in terms of the Constitution and also in terms of statute law? Well, the courts have effectively established that there are 4 golden rules in order to ensure that lands are being lawfully compulsorily acquired. The first is that the acquisition is authorized by statute. Secondly, that the acquisition is being pursued legitimately for the authorized purpose. Thirdly, that the acquisition of the land is actually necessary for that authorized purpose. And finally, that the land is to be acquired in the minimal quantity possible in order to advance the statutory purpose. So if we take the last point for a moment and think of a rather esoteric example, it would not be lawful for a local authority, for example, to exercise powers of compulsory purchase over 153 hectares, where in fact they only required 2 hectares of land for a particular statutory purpose. So there must not be an overreach, there must not be a disproportionality in the exercise of the acquisition powers. And one will see flavours of those particular currents set out in a number of cases, such as Crosby, Clinton and Reid and the Industrial Development Authority, which concerned acquisition by the Industrial Development Authority for Intel in and around Maynooth in County Kildare. And that again, even by nature of the names of the cases, gives an indication of the wide number of bodies which are authorised to exercise statutory powers. And we turn to certain of those in due course. Next slide, please. So in terms of the statutory framework for the exercise of compulsory powers, in 2000, when the Planning and Development Act was promulgated, the Oireachtas attempted to gather together, if you like, in most circumstances, a particular statutory scheme for the exercise of compulsory powers. So in section 213 of the 2000 Act, one will see provisions which are directed to a local authority, but the definition of a local authority is so broadly cast that it captures a number of non-local authorities in addition. So for ease of reference, in the square bracket, you'll see that I have substituted the words acquiring authority for local authority, because that's effectively how you read these provisions with cross-referencing to an appropriate statute dealing with, for example, individual powers of acquisition by a water authority or a road authority, as the case may be. So under subsection 1, the power conferred on an acquiring authority under any enactment to acquire land shall be construed in accordance with this section. So you will find in a whole plethora of statutes, Arterial Drainage Acts, Roads Act, Water Services Acts, Electricity Supply Acts, certain provisions of compulsory acquisition exercised by public bodies. In addition, of course, to the traditional powers of the local authority to exercise compulsory purchase. And then in subsection 4, an acquiring authority may be authorised by compulsory purchase order to acquire land for any of the purposes referred to in subsection 2 of this section. And that's more usually directed towards local authorities as we know them. There's a long list of statutory purposes for which local authorities can seek to compulsorily acquire land. And as Elaine mentioned at the start of the presentation, that procedure is effectively the Housing Act of 1966 procedure adapted to these various statutory schemes. And then finally, in the context of the 2000 Act for present purposes, section 214 subsection 1 provides that the functions which were conferred on the minister in a number of statutes in terms of confirming compulsory acquisition of land by local authority have been transferred to and vested in An Bord Pleanála, now known, of course, as An Comisiún Pleanála. So again, in individual statutes, such as the Road Act 1993, for example, one will see reference to the minister's power to confirm compulsory purchase orders. And of course, by dint of section 214, where one sees the word minister, one effectively now reads in An Comisiún Pleanála as the confirming authority. Next slide, please. There are therefore a number of individual statutes which set out individual powers of compulsory acquisition to specific statutory bodies. And 3 examples have been cited in this slide and the next slide. The first is the Water Services Act 2007, which pursuant to subsection 93(1 provides that Uisce Éireann is a water services authority, and that act provides powers of compulsory acquisition to water services authorities, thereby including Uisce Éireann, enabling UE to acquire land for the purpose of performing any of its functions under that act. And that act then applies Part 14 of the Planning and Development Act 2000 to a water services authority, thereby providing for the power of compulsory purchase. So one sees here the interlinkage between individual statutes which set out a provision for a particular body to acquire land and the procedure contained within Part 14 of the 2000 Act. And then in similar terms, the Roads Act of 1993, specifically in this example, subsection 47(1), contains a general acquisition power authorising a road authority to acquire a land or substratum of land, rights in relation to land, and also to extinguish any public or private rights of way. And again, the definition of a road authority includes not just a local authority exercising its powers under the Roads Acts, but also Transport Infrastructure Ireland in a particular case. And again, one will see a cross-referencing to Part 14 of the 2000 Act in relation to the exercise of those powers of compulsory acquisition. Next slide, please. Slightly differently, the Electricity Supply Act of 1927, as amended on a number of occasions, makes provision for the exercise of certain compulsory powers by the ESB. Specifically, subsections 53(1) and 53(9) give the ESB the power compulsorily to place electric lines on land and to enter upon those lands subsequently for the purposes of maintenance, for example. And after the Gormley case in 1985, the ESB Act was amended further so as to ensure that where either or both of those powers is invoked by the ESB, either to place a line on land or to enter upon those lands for the purposes of maintenance, etc., the owner or occupier of the land is entitled to compensation pursuant to subsection 5 of section 53. So this doesn't in the same way invoke Part 14 of the 2000 Act, but as one will shortly see, it does invoke the assessment of compensation provisions under the 1919 Act, to which we'll shortly turn. Next slide, please. So what is the statutory process then for assessing the compensation? We can assume at this point that the statutory body, the acquiring authority, has acquired either land in toto or certain interests in respect of land, and a person who holds an interest in those lands, whether as owner or occupier, whatever the case may be, will then consider the process by which he, she, or it may be compensated for that infringement of their undoubted constitutional rights. So effectively, very many individual statutes make provision for compensation payable in the same manner as acquisitions under the Housing Act 1966. And that means, in effect, as Tom will identify in more detail later, there are certain rules and principles that apply in relation to the assessment of such compensation, which are set out not only in the 1919 Act, but also have been added to in the Housing Act of 1966 and indeed subsequently by the Planning and Development Acts. The claim for compensation made by an occupier or owner of lands post the CPO being made is determined by arbitration in default of agreement. And that arbitration is convened by a property arbitrator appointed by the Land Values Reference Committee, which Elaine touched on earlier. And there is a whole process involved with such an arbitration. So the first thing to note perhaps is that the property arbitrator is a creature of statute, which means he or she, although I think they've nearly all been he, does not have any self-standing or inherent jurisdiction. The property arbitrator only has the limited jurisdiction afforded to him under the various acts, particularly the 1919 Act and the Property Values Arbitration and Appeals Act of 1960. And as I mentioned a moment ago, when it comes to the assessment of the quantum or amount of compensation, the property arbitrator is subject to the rules applicable in the 1919 Act as amended and extended by the 1966 Act and indeed subsequently by certain provisions of the Planning and Development Act. So we have this statutory office holder, the property arbitrator, assessing and determining claims for compensations made by owners or occupiers where lands or interests in lands have been compulsorily acquired by certain public bodies. Next slide, please. And whilst Tom will touch on certain of the valuation principles in more detail in his presentation shortly, there are perhaps two specific legal principles to identify at the outset. The first is the value to owner. That principle is central to the assessment of compensation. And that means it's a subjective assessment as to the value of the land to its owner rather than the value of the land to the acquiring authority. And that value includes market value as provided under the 1919 Act, but also any personal losses that may be imposed upon the owner or occupier by the forced or compulsory sale of his, her, or its interests in those lands to the acquiring authority. And an important principle, which Tom will touch on in more detail, is the principle of equivalence, established or at least enumerated by the English courts in Horne and Sunderland Corporation and adopted on many occasions by the courts in this jurisdiction. And perhaps at this stage it is appropriate to give a shout out to the authors Galligan and McGrath of the seminal text in this area, Compulsory Purchase and Compensation in Ireland, Law and Practice, the second edition of which was published in 2013 and is without doubt the starting point or the first point of return for any person seeking to interrogate any legal issues in relation to the issues of compulsory purchase and acquisition. Next slide, please. So there are certain procedural issues that are important to keep an eye on when one is advising clients in the context of the compensation assessment process. And one of these in particular has been the source of a few recent Superior Court's decisions, and that is the issue of an unconditional offer. So we move here perhaps away from the substantive law and more to the procedural, but important procedural safeguards in one respect knitted into the 1919 Act under Section 5, subsection 1, which enables an acquiring authority to make an unconditional offer to the person whose rights have been acquired as to compensation. And the significance of such an unconditional offer arises from whether or not the claimant ultimately beats the offer. In other words, if the claimant is offered €100,000 by way of unconditional offer as compensation in respect of his, her, or its claim, and the property arbitrator awards less than that sum, perhaps €75,000 to the claimant will have to not only bear his own costs from the date of unconditional offer forward, but will have to actually pay the costs of the acquiring authority incurred after the date of unconditional offer. So it is an important procedural aspect of the compensation assessment process. And in two cases, which I mentioned on the slide, McCarthy and Kelleher, aspects of that process were interrogated by the High Court in the person of Mr. Justice O'Moore. And in the first case, McCarthy, Mr. Justice O'Moore held that the acquiring authority is entitled to make more than one unconditional offer. So if we imagine for a moment a scenario whereby a claimant may file an amended claim, amended points of claim, perhaps making a larger monetary claim for compensation than originally done, well then in that context, for example, it's clear that the acquiring authority will have the entitlement to deliver a second unconditional offer if it so wishes to take account of those change in circumstances. Similarly, Mr. Justice O'Moore held in the case of Kelleher that an unconditional offer can be accepted by a claimant at any time prior to the making of the award by the property arbitrator. And that may or may not have certain cost consequences depending on the point of time at which the unconditional offer is accepted. But it's clear from that decision that a claimant does have that discretion to accept the UO right up to the date of the award of the arbitrator, which of course will become after the hearing has ended. The next slide, please. The second issue, which hasn't been as much focused upon in recent times by the courts, but which may yet in due course cause some issue to be determined by the courts, is the issue of interest. And it's a common misconception as to whether the property arbitrator himself has the power to award interest. My view is that he does not, because the 1919 Act does not contain such an express provision enabling a property arbitrator to award interest. And as we know from Cork County Council and Lynch in the Court of Appeal, per Mr. Justice Murray, the property arbitrator is a creature of statute and is restricted by the parameters of this jurisdiction given to him under statute. However, other statutory provisions make clear provision for the payment of compensation, in other words, outside the assessment process. And one example of that type of provision is Section 80 of the Housing Act 1966, which makes provision for the payment of compensation and interest, where, as usual, entry occurs on foot of a notice of entry prior to the assessment of compensation. And one is entitled to interest in that scenario as in from the date of entry. And one particular issue that arose in the Murphy and Dublin Corporation case and may arise in the future is the quantum or amount or rate of interest to be paid where entry occurs, as is usual, prior to an award of compensation. And it's clear that interest is payable from the date of entry pursuant to the provisions of paragraph 2J of the third schedule to the 1996 Act. But what is less well known is that the rate at which that interest is to be paid is not 5%, but rather is the local loans fund rate, which is now known as the Exchequer lending rate. That's a floating rate, which is not 5%, and at one recent time in the past dropped as low as 0.05%. So it's an important point to note when advising both claimants and acquiring authorities as to the rate of interest which is payable by an acquiring authority to the claimant, outside, if you like, the assessment of compensation by a property arbitrator. Next slide, please. And then finally, just to point out that challenging a CPO to acquire lands is done by way of judicial review pursuant to Section 50 of the Planning and Development Act 2000 within an 8-week period, whereas a challenge to a decision made by a property arbitrator is brought forward by way of Order 84 of the Rules of the Superior Courts within a 3-month period. And it's perhaps notable that the property arbitrator generally does not participate. The row, such as it is, will be between the claimant and the acquiring authority. Next slide. Thank you very much indeed.
Thank you very much, Jarlath. We're going to pass over now to Tom just to speak to the valuation and compensation principles. Thanks, Tom.
Thanks, Elaine. So I might just move on to the first slide, please. So again, my name is Tom Kirby. I'm a director and principal with Avison Young. I've specialised in CPO infrastructure acquisitions for over 25 years. And again, just to kind of briefly outline firstly what we do, and then I'll go into the main headings of claim for compensation. So really any person joining our team, kind of, I think the key skills to be a CPO surveyor is you need to be able to value. I was taught at a very early stage that when you're looking at a claim for compensation, one of the first questions you ask yourself is, what's the value of the entire property? If, say, you're looking at a 100-acre farm and it's worth €1 million and 5 acres have been acquired and the claim is $750,000, there's possibly something wrong with the claim. So we always need to ask ourselves, we always need to be able to value property, look at property. So valuation is a key skill. We have to be able to negotiate. I believe a CPO surveyor will do more deals than any other part of the property profession. We're doing deals every day of the week across all types of infrastructure. So you have to be able to negotiate. And to me, negotiate isn't just about putting out an offer. You have to have a plan, a strategy for each individual case, depending on the merits of the case, who are involved in the case, etc. So again, negotiation skills are key to being a CPO surveyor. As Jarlath and Elaine have both outlined, there's a huge raft of case law legislation, and a CPO surveyor needs to be able to apply that and needs to understand and apply that that legislation in coming up with estimates of compensation and agreeing cases. Empathy is a huge part of being a CPO surveyor. Both acting for property owners and acting for acquiring authorities. In many cases, this is one of the biggest things that happen to a person. If it's a family farm, it may be in the family for generations, and they're having to, I suppose, sell part of the farm, in some cases unwillingly. It could be someone's family home that's been acquired, and that's hugely kind of difficult and upsetting for people. And again, as a valuer acting for the claimant, you have to help guide them and help them in that process. Valuer acting for the acquiring authority, I think we need to be alive to that and give people time to process all of that as well, because it is a difficult thing having to deal with a CPO of your property. In terms of arbitration or third-party hearings, a valuer has to be able to, a CPO valuer has to be able to be expert, provide evidence as expert witness, prepare presses of evidence, work as part of as a larger team in preparing for hearing, and then at arbitration hearing. In my experience, arbitration hearings are far more adversarial. You need to be you're challenged far more at arbitration by barristers for either side. So you need to be able to present your evidence and stand over your evidence. That is a key trait required to be a CPO surveyor. In dealing with infrastructure, we deal with all types of property. I was walking land yesterday, farmland up in Oma yesterday. I was on a boat in the Shannon last week, and a few weeks ago I was looking at development sites in North County Dublin. So you deal with all types of property all over the country. And again, you also need at times to be aware of your limits. I mean, say, for example, a couple of years ago, we were dealing with buying an active apple orchard. So we needed to bring in people to help advise us on the value of the orchard, the value of apples. You deal with all types of property. And as I say, when it's outside your area, you need to obviously bring in extra help. When we move on to the next slide, please. In terms of the projects, there's a whole variety of projects. I think there has been a huge transition over the last 25 years. When I started in the 2000s, the road program was at its height. There was all the interurbans were being done. Our office bought all the lands from Dublin to Galway, a good share of the land from Dublin to Limerick. And there was a huge amount of work I would say 80–90% of our work in our office in CPO in the 2000s was all on the roads. That's changed now. And we see it in the press or in the media every day in terms of the need for energy, the upgrading of water, wastewater, more public transport. That's where the focus now we see more in CPO is in those types. There are still roads being built, but to a lesser degree, it's more on utilities, public transport, greenways, and even now the derelict sites. You see a lot of local authorities using their powers to acquire one-off houses for derelict sites. And furthermore, again, we're starting to see a bit of local authorities acquiring lands for housing, and the Department of Education are always funding the acquisition of sites for housing as well. We'll just move on to the next slide, please. Jarlath touched on Horn v Sunderland. I think this principle of equivalence is, I suppose, one of the main overarching themes we need to be conscious of when we're assessing compensation, and that is that the property owner, landowner, has the right to be put so far as money can do in the same position as if the land was not taken from them. So we need to replace the property taken with money, in effect. That's the best we can do. Albeit the law, we can't go give them, it's put them back in the same position, but not a greater position. So that principle of equivalence is kind of overarching in all of our compensation assessments and negotiations. So just move on to the next slide, please. So I'm just going to run through very quickly the main headings of claim. We're looking at compensation claims, either acting for claimants or acquiring authorities. As Elaine mentioned, land is valued as of the date of notice of treat. So that goes for the value of the land, any injuries, affection, severance, whereas disturbance is actual. Disturbance is an actuals payment. So what I mean by actual is that we kind of have regard to when the works take place, how long the works take. So the disturbance assessment isn't necessarily fixed to the date of notice of treat. So I've just, in italics there, you'll see the definition for Rule 2. There's 16, 17 rules of compensation, but Rule 2 defines as to how the value of land is to be determined. And it's similar to the Red Book definition of market value, whereby it's the land sold in the open market by a willing seller. So in considering Rule 2, we have to consider the no scheme world, have to value the property in the no scheme world. And this is a critical theme we have to have regard to. I might just go on to the next slide and use an example. So we were involved, actually Jarlath and Elaine were as well, and on the acquisition of a site in Arklow. And site is shown in blue on the screen there. It's just very close to Arklow town centre at the mouth of the River Avoca. The site was a former wallboard factory, and Ishgaren included in their CPO to construct a wastewater treatment plant, which is actually seen there on the right-hand side. And I think the actual structure has won awards or is up for awards, architectural awards. But aside from that, we have to assess compensation in the no scheme world. So what that means is we got claim for compensation in. Compensation was based on the zoning of the land, which was a waterfront zoning, which allowed for all types of commercial and residential development. However, when we kind of consider this, it was clear to us that in the no scheme world, that is on the basis there was no new sewage treatment plant being provided in Arklow, there would have been no development on the site. We looked at planning applications, we looked at development which had occurred in the Arklow area, and there was very little new development in Arklow because there was no capacity in the existing sewage treatment plant. And where there were some smaller plannings granted, they were only granted in the knowledge the scheme was being provided, and were also, say, for office buildings subject to occupancy clauses. There's only a limited number of people could occupy the office building that was granted. So any planning was granted in the knowledge of the scheme. So our position was, in the no scheme world, if there was going to be no new treatment plant, there would have been no development on the site. And the significance of this is that on that basis, then, who would pay full development value for a site that had no development potential, notwithstanding its zoning? So our view was, before the arbitrator, was that the land's value was significantly discounted from what the zoning would be in a scheme world. And I suppose to further support our case, there was no actual sales of development land in Arklow to support the values claimed by the claimant. Again, as this is all before an arbitrator. The comparisons were used in areas outside of Arklow, which supported the view that there was no development in Arklow, despite the rising economic conditions, because there was no sewage treatment plant. And we have seen since the construction and the operation of the plant that there is now new residential development in Arklow. So that no scheme world principle is critical in assessing compensation, and we always must have regard for the no scheme world as of the date of notice to treat. So just move on to the next slide, please. So, and just the other, I suppose, typically when we're looking at land values or at the value of land to be acquired, we're looking at comparable sales, and in doing that, we're out looking at what lands are selling in the market. Again, trying to, if there are outliers in sales, we're looking at saying, well, is that land being bought in the scheme world off the back of the scheme, or is it actual market? So we're all the time principally looking at comparable evidence. There is a concept of ransom value, which comes up from time to time. This is in the case that a colleague of mine in the office was involved in, again, went to arbitration and went to awarded arbitration. And when we talk about ransom value, the main case spoken about is Stokes v. Cambridge UDC, where the Cambridge Urban District Council acquired lands which held the key or the access to other backlands. The owner of the lands which held the key said, "You have acquired my ransom or key value, and I want a premium for that." And the Lands Tribunal in the UK held with that and allowed the landowner 1/3 of the uplift in value of the lands that were unlocked, or the backlands. So 1/3 of the uplift in value. The Stokes principle is often taken as a rule. That, in my view, is not the case. Each case must be assessed on its own merits. For example, the case we're looking at there now, this is kind of between Bettystown and Laytown in County Meath. The lands in the pink shade were the lands that were acquired from our client. The lands outlined in red were all backlands that were inaccessible. The railway bordered one side, and all of the houses along all the road frontage along the Bettystown Road was removed. So therefore, our position was our client held the key to all of the lands inside that red box, and he needs to be paid a premium to reflect that. I suppose in our case, it was further supported by that there was approaches over the years by developers looking to acquire the site from him for access to their lands inside the red box. So that supported our case before the arbitrator, and the arbitrator held with that position. In my view, again, when we're looking at ransom claims, kind of the first question you have to ask yourself is there a ransom? Is there ransom there in the first instance? If there is, what's the strength? I don't think that, as I said, the Stokes principle or the 1/3 of the uplift is not or should not be taken as read. You have to ask yourself what would happen in the market. If this was a developer looking to buy the access point in, what would the developer do? Would the developer find a workaround? Would they they would look at their scheme viability. If what the person who holds the key or holds the ransom strip is looking for a king's ransom as such, the developer may not pay that and will park the development. So we have to ask yourself what the developer will do, because scheme viability, or developer scheme viability, is a question he'll be looking at and considering in what price the developer can afford to pay for the ransom. So let's move on to the next slide, please. So just moving on to the next heading of claim, which is, I suppose, severance and injurious affection. This is devaluation to the retained property as a result of the scheme. So there's two parts to this we would typically consider. They're often measured together, but we consider separately, or I mean, I'll just identify them separately. Severance is it may be the physical separation of the property. So you may have a 50-acre farm and a road slices through the middle of it. You might have part of the farm held with the yard and house, and the balance is severed or separated, and access to that might be circuitous, or there may be a loss of usable road frontage, or access maybe down a shared road. And all of these factors would have to be considered into the impact on value to the retained lands. Normally, you'll measure the impact. There's two ways you can measure the impact on the value, either by looking at a before and after value. So what was the value of the lands in the no scheme world and post scheme? And you're considering issues like access, perhaps change in environment, the configuration of the lands, the size of the retained lands, etc. Severance can also mean the reduction in size of the holding. So say you had a 50-acre farm and half it was acquired. Is the holding as a 25-acre holding still as attractive as a 50-acre holding? And if not, that depreciation in value needs to be accounted for. The other part of severance, a devaluation, is injurious affection, and that's the case often cited here is the Edwards principle. It's the English case, and in effect, what it says is the claimant is entitled to devaluation or injurious affection arising from the works taking place on the lands acquired from the claimant. So that's the critical bit. Devaluation arising from the works taking place on the lands acquired from the claimant. And that's kind of reaffirmed in Irish law now by the Chadwick and Fingal County Council case. So I might just go on to the next slide, please. So this is a case, this is when the Northern Motorway was built in the early 90s, early 2000s. This is just north of Swords. There's a bridge there crossing the Broadmeadow Estuary. And as you go on the north heading for Belfast, you'll see on the left-hand side, immediately north of the estuary, you'll see Lisson Hall, which is outlined in red there. And what was acquired from by Fingal from the Chadwick or Lady Sheila Goff, was a sliver of land at the end of the garden. What was constructed on the sliver of land was to tow the embankment of the motorway. So the motorway was on a height as it crossed, it bridged over the estuary, and a sliver of land of the tow of the embankment was on the lands acquired. Case went to arbitration. The arbitrator stated a case to the High Court. The position of the claimant was that they were entitled to devaluation to their property as a result of the noise from traffic, the light from traffic, the motorway lights, and the visual impact to their property, which is a stately home. But none of that work, none of the noise, none of the visual impact or the lights were on or coming from lands acquired from the claimant. They were all on third-party lands. So the High Court held that the Edwards principle held that principle. And as I understand it, the rationale behind the principle is that the state is providing such an infrastructure for the public good. And therefore, there has to be some limit on the state's exposure to compensation. So the critical impact in assessing injurious affection is what works are taking place on the lands acquired from the claimant. So we might just move on to the next slide, to disturbance, please. So disturbance, again, as I said earlier, the losses are actual, not fixed to date and notice to treat. There can be disturbance, temporary disturbance or permanent disturbance. And the disturbance really, again, temporary disturbance, take, for example, a pub beer garden, and that was temporarily acquired for a period during construction. We may look at accounts, what's happened for the last 2 or 3 years, and what's happened the year the construction was happening, and you measure disturbance accordingly. equally, say, take your example of the pub again, as a permanent acquisition of the beer garden. And again, you would look at the accounts, but you might capitalize the loss of income as to what the permanent disturbance was as a result of the works. What acquiring authorities need to be careful of is that if the claimant also claims for devaluation to the property due to the loss of the beer garden, and also claiming the permanent loss of income, there's a potential there for loss of a double count. And really, we can't, the double counting of compensation is not allowed. So really, disturbance is any disruption or additional costs that are incurred as a result of the works that can be justified. So just move on there, please, to the next slide. And again, I'm just coming back to Horn v. Sunderland there very quickly. This is the principle of equivalence. This is a case on the M3 we were involved in a number of years ago. And the issue here was housing was creeping out to this site, zoning was creeping out to this site. And what was the best way to run the case? Was it a development land value case, or was it an existing use value as an agricultural land value together with disturbance to the dairy operation? Which way should the case be approached? So it was up to the claimant's valuer to advise the claimant what's the higher value approach. The claimant couldn't pursue a claim for development value and the loss to the enterprise, the business enterprise, the farming enterprise. Whereas, I mean, in the no scheme world, if they were to sell the development land, they would get the development land, and a developer wouldn't necessarily pay them to get out of cows as well. So it's kind of one or the other. The claimant has to decide which way they want. They're entitled to go the higher value approach. So the claimant's valuer should be advising that the higher value approach is either, say, the development value approach or it's existing use plus disturbance to the farming operation. Again, that's back to Horn v. Sunderland from the principle of equivalence. And so I just might move on there, please. I'm just quickly going to touch on way leave compensation, and I might just go to the next slide straight away because I'm conscious of time. So that's typically a track there for a pipe that's 30 meters wide, and on the right hand picture there, that's post-construction lands have been reinstated. But typically you've got the working width, which would be, it depends on the size of the infrastructure, could be up to 30 meters wide, could be 50 meters on bigger cases, and the claimant is entitled, the landowner is entitled to compensation for the disruption during the works, the extent of time of the works take place, and if there's any kind of follow-on damages. For disturbance, that'll cover the 30-50 meter wide working width. And then there will be compensation for the permanent way leave, which is the encumbrance on title, so the burden be registered on title, but also the restriction in use. So, you know, typically the restriction in use would be you cannot construct buildings over the permanent way leave, which could be 8, 10, 14 meters wide. And you may not be able to plant certain, say, deep-rooted crops or deep-rooted shrubbery or trees. In more urban areas, you do see kind of way leaves and car parks, roads constructed over same. So it can be worked around, but you will not see permanent buildings built over way leaves. So each case is typically assessed on its own merits, whereas in an urban area, whereas in a rural area, it's generally measured on a rate per linear meter. So I might just move on there, please. So just very quickly to finish from me, just on accommodation works, any compensation agreement we meet in terms of money, we need to have regard for the agreed accommodation works. If it's, say, a house case, part of the front garden is being acquired, an allowance needs to be, you know, if the acquiring authority is providing a wall, that needs to be recorded as part of the agreement. If the acquiring authority is not providing a wall and one is required, well, then that should be costed into the compensation settlement. So any agreement needs to record 1, the money, and 2, the accommodation works being provided. Finally, fees. The acquiring authority is generally responsible for reasonable legal and valuer's fees, and if other experts are required, that's considered in a case by case. So Elaine, I'm just conscious of time, so I'll hand back to you.
Thanks so much, Tom. Yes, we're running short on time now. We've only 6 minutes left, so I think we'll just kind of touch briefly if we go to the next slide. And I suppose we just want to, give the attendees some practical tips really in terms of this next step, which I suppose if compensation can't be agreed, there is that reference to arbitration that Jarlath has alluded to earlier in the presentation. So I suppose when an arbitrator is appointed, they generally is a meeting, there's direction set. The first of those directions, I suppose, Jarlath, is generally that kind of delivery of the statement of claim and the reply to same. So obviously, this is can be quite claim specific in terms of what the legal strategy and advice would be. But just in your perspective, is there any kind of general at the outset? You're on mute there, Jarlath.
Thanks, Elaine. An important practical tip is to ensure that the valuer is inherently involved, both obviously enough in drafting the points of claim for a claimant, but also when the acquiring authority comes to set out its stall in its points of reply. So very often solicitors and barristers will be instructed by a client, an acquiring authority, to prepare a draft of a points of reply. This can be done perhaps under quite tight timelines of perhaps 2 weeks. So it's extremely important that the valuer, whose role is central, as Tom has identified, is briefed and retained and ready to roll by the time the statement or points of claim are delivered, because that's the opportunity the acquiring authority has to set out its stall as to why the claim is unfounded in certain respects, or perhaps exaggerated in other respects, or any other issues of valuation principle that arise, because it will be too late when submissions are being filed in advance of a hearing or at the hearing itself to have set out a stall that has not been prefigured in the points of reply. So wrap your arms around your valuer early if you're an acquiring authority. Of course, if you're a claimant, you've engaged in that embrace much earlier in the process.
And I suppose that it's the valuer, but I suppose it's also looking at the kind of different aspects and issues arising as well, Jarlath, isn't it? And that kind of wider expert evidence. So I think it can't be understated, I suppose, the importance of kind of early engagement of those key experts where issues arise in terms of your engineers, your surveyors, in terms of the plot, etc. And there's also, I suppose, in terms of that multidisciplinary team, there really is, I suppose, that, the importance of having those kind of strong witnesses if you were to go to arbitration, and that kind of understanding across the evidence. Tom, I don't know, from your perspective, is there any, I suppose, kind of practical advice or tips, or from your experience, have you?
Yeah, like for me, kind of working with the barristers, or working with yourselves, like yourselves, Elaine, it's very obviously you guys are very much the kind of the coordinating the thing, but like working with when it's across a multidisciplinary team, it's important that the different experts are working together. There's no point in all the reports going in separately into the legal team, and I think we all need to know each other's evidence, particularly sitting as the valuer, because it all comes back to us. We have to draw from the other evidence to come up with a number in compensation. So in my experience, the teams, the arbitration teams that work best together, the teams that are kind of maybe sitting in a room together, going on calls together, working together, so we all understand each other's positions and they can be ironed out, as opposed to reports going in separately. Again, just appearing as expert. Again, our duty is to the arbitrator when we're there, so we need to be very conscious of that and not going out on a limb for a client. In the end, you're not doing a client any favors by going out on a limb. We need to make sure we can stand over our evidence. The other thing I've seen is certain people drawing conclusions, or certain valuers drawing their own conclusions of their other experts' witnesses. I think we need to make sure that whatever the planner says, whatever the engineer says, that we follow that evidence. We can't decide we don't like their evidence and put our own twist on it. We need to very much follow the evidence of, it sounds very obvious, but it does happen that somebody puts their own twist on the evidence.
So there's a question just in terms of the timelines of the CPO process. And I know we discussed this, that this can be a very long drawn out process, particularly, I suppose, in terms of that second part of it, in terms of agreement of compensation, which I suppose can be very costly to both parties involved. So Jarlath, I know we touched on unconditional offers, but obviously in terms of settlement, that is another kind of key aspect to it. And I'm just very conscious we're out of time nearly now, but I know you mentioned, Jarlath, you have been involved in mediations, etc. Like so, an unconditional offer obviously is that key step as well in terms of settlement.
Yes, indeed. It can be a very long process. It can be a very expensive process, both for the claimant and for the acquiring authority. So mediation increasingly is coming to the fore in the resolution of the compensation claim. And certainly success can be garnered at an early stage through mediation. If mediation or any other sort of alternative dispute resolution is not working or not available for various reasons, then the unconditional offer has a particular value. And of course, the earlier the unconditional offer is made from the acquiring authority's perspective, the more value it has. And perhaps even from the claimant's perspective, the claimant at least will know in early course what the acquiring authority's view is of his, her, or its claim, and then can take its own advice and undertake its own consideration as to whether that's a reasonable offer in all the circumstances. So it certainly brings a different dynamic to the risk reward equation faced both by claimants and by acquiring authorities.
So I'm conscious that we are unfortunately out of time. I'm conscious we didn't get to some of the questions raised. So if people want to contact me directly, my email was at the very outset, and I can respond in writing to any of the questions raised. And I'd like to thank everyone for attending. In particular, I'd like to thank Tom and Jarlath for your time today. So thank you very much both. And I hope that was useful in some respect. Thank you all.